Hi everyone, today I'm doing a comprehensive review of the proposed Entrepreneur Parole program recently announced by DHS. The thorough breakdown of the program will include some of my own notes and opinions as well. Welcome to the Immigration Lawyers Podcast. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult an immigration attorney for specific information related to your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. On August 26, 2016, the Department of Homeland Security, also known as DHS, announced a proposal implementing a discretionary parole authority to increase and enhance entrepreneurship, innovation, and job creation in the United States. This is an interesting new way for foreigners to enter the U.S., which has been talked about for some time. Note that this is different than the EB-5 Immigrant Investor Program, which leads to lawful permanent residency in the U.S., or the E-2 program that allows a renewable investment-based non-immigrant visa for a foreign investor from a treaty country. The proposed rule would add a new provision allowing the use of parole on a case-by-case basis with respect to entrepreneurs of startup entities whose entry into the United States would provide a significant public benefit through the substantial and demonstrated potential for rapid business growth and job creation. This was partially done to compete with other countries that are doing similar programs. DHS has discretionary authority to parole individuals into the United States on a case-by-case basis for urgent humanitarian reasons or significant public benefit. DHS estimates that 2,940 entrepreneurs could be eligible for this type of parole annually. Note that this regulation is not limited to tech entrepreneurs, but practically speaking, they will be disproportionately using it. DHS has given a 45-day comment period before finalizing this proposal. To grant parole, adjudicators would be required to conclude, based on the totality of the circumstances, that both 1. The applicant's parole would provide a significant public benefit, and 2. The applicant merits a grant of parole as a matter of discretion. The text of the proposal can be found at uscis.gov. What does the parolee get? Parole is a temporary permission to enter the United States and is not considered admission or a grant of status in the U.S. Because parole does not constitute an admission, individuals may be paroled into the United States even if they are inadmissible. If trying to change or get status, the parolee would have to exit the U.S. and re-enter with that status after going through the proper procedures. If granted, this type of parole would provide a temporary initial stay of up to 2 years, which may be extended by an additional 3 years for a total of 5 years, to facilitate the applicant's ability to oversee and grow his or her startup entity in the United States. Their spouse and minor unmarried children would also be able to apply for parole through separate applications. The entrepreneur would be authorized for employment incident to the grant of parole, but only with respect to the entrepreneur's startup entity. The permission for the employer's I-9 would be shown through the parolee's I-94 and would not require an employment authorization document, EAD. The entrepreneur's spouse could apply for an EAD once in the U.S., but children are not permitted employment. Aliens who seek parole as entrepreneurs under this rule may need to apply for advanced parole if at the time of the application they are present in the United States after admission in a non-immigrant classification, as U.S. Citizenship and Immigration Services, USCIS, is unable to grant parole to aliens who are not applicants for admission. DHS would assign a new code for admission for this class called PE-1. Only 3 entrepreneurs per company are allowed. DHS will issue a multiple entry travel document for individuals granted parole under this rule to permit travel during their validity period. The process. The requirements for an applicant for parole include the following. First, filing the application for entrepreneur parole with the not yet published Form I-941 or successor forms. An application filing fee of $1,200 plus $85 for biometrics has been proposed. Dependents can apply by filing Form I-131. Second, DHS is proposing a biometric collection requirement so that background checks can be completed for each applicant and so that any necessary travel document can be produced. First, applicants applying from within the United States will be required to appear at a USCIS Application Support Center for submission of biometrics. 2. Applicants applying from outside the United States may be required to appear at an overseas USCIS office. Applicants who will be receiving their travel documents overseas from a Department of State consulate or embassy will have their biometrics taken after their parole is authorized, but before the travel document is issued. Third, and an important note, there's an income-related condition on parole. DHS is proposing that an individual who is paroled into the United States under this rule must maintain household income while in the United States that is greater than 400% of the federal poverty guideline for his or her household. Under the proposed rule, DHS would be authorized to terminate parole for any individual who fails to maintain the threshold income level. DHS would request verification of the parolee's household income when the parolee applies for reparole, if applicable, or subsequent to any material change notification submitted by the parolee to USCIS. The income level necessary for a family of 2 is $64,000 and $97,200 for a family of 4. 4. The income threshold and time limits on parole also mean that individuals eligible for parole under this rule would generally not be eligible for federal public benefits or premium tax credits under the health insurance marketplace of the Affordable Care Act, also known as Obamacare. Footnote 38 in the proposed regulation states that, quote, although individuals who are granted parole for more than 1 year become qualified aliens for the purpose of applying for such benefits, such individual must generally be qualified alien for at least 5 years before becoming eligible for those benefits. Individuals paroled under this rule will thus not qualify for such benefits, close quote. 5. DHS retains the discretion to provide any length of parole to an applicant, including a period shorter than 2 or 3 years when appropriate. Moreover, U.S. Customs and Border Protection, CBP, would retain the authority to deny parole to an applicant or to modify the length of parole authorized by USCIS upon issuing parole at the port of entry. Now we're going to get into the meat and potatoes of what has to be shown to prove the candidate's quality for admission under this rule. An individual seeking to operate and grow his or her startup entity in the United States would generally need to demonstrate the following to be considered for discretionary grant of parole under this proposed rule. 1. Formation of a new startup entity in the U.S. that has lawfully done business since its creation and has substantial potential for rapid growth and job creation, including through the significant attraction of capital investment or government awards or grants. DHS proposes that an entity may be generally considered recently formed if it was created within 3 years preceding the date of the filing of the initial parole application. It is not clear whether an e-visa or AB5 style business plan is required. DHS believes that evidence such as the following would assist USCIS officers in determining whether an entity has substantial potential for rapid growth and job creation, and ultimately whether an applicant has met the required standard for parole and merits a favorable exercise of discretion. This includes evidence of capital investments from qualified investors or government awards or grants, other than those relied on to satisfy the requirements. Letters from relevant government entities, qualified investors, or established business associations with knowledge of the entity's research, products, or services, and or the applicant's knowledge, skills, or experience that will advance the entity's business. Newspaper articles or other similar evidence that the applicant or entity has received significant attention or recognition. Evidence that the applicant or entity has been recently invited to participate in, is currently participating in, or has graduated from one or more established and reputable startup accelerators. Evidence of significant revenue generation, growth in revenue. Patent awards or other documents indicating that the entity or applicant is focused on developing new technologies or cutting-edge research. Evidence that the applicant has played an active and central role in the success of prior startup entities. Degrees or other documentation indicating that the applicant has knowledge, skills, or experience that will significantly advance the entity's business. Payroll, bookkeeping, salary, or bank records or other documents relating to jobs created prior to filing the request for parole. And finally, any other relevant, probative, and credible evidence indicating the entity's potential for growth and or the applicant's ability to advance the entity's business in the United States. The second thing to show is that the applicant is an entrepreneur of the startup entity who is well positioned to advance the entity's business. DHS proposes that an applicant may generally meet this standard by providing evidence that he or she A. possesses a significant, at least 15% ownership interest in the entity at the time of adjudication of the initial grant of parole. Ownership can decrease to 10% after granting of parole and for the extension. Ownership must be properly documented with copies of legal or financial documents, such as formation and organizational documents, equity certificates, equity ledgers, ownership schedules, or capitalization tables, indicating the applicant's ownership interest in the startup entity. B. They have to have an active and central role in the operations and future growth of the entity, such that his or her knowledge, skills, or expertise would substantially assist the entity in conducting and growing its business in the United States. Such an applicant cannot be a mere investor. Hopefully, this requirement is not as stringent as the ILP017 style breakdown of duties. As part of the application process, an applicant would generally be expected to submit supporting documentation concerning the entity's business and its substantial potential for rapid growth and job creation, and the entrepreneur's day-to-day role in the business. DHS expects that an applicant would provide supporting documentation of his or her role within the entity, as well as the knowledge and expertise that is central to the entity's business. Such supporting documentation may include letters from government agencies, qualified investors, established businesses, and associations, with an understanding of the applicant's skills, experience, and knowledge that would advance the entity's business. Newspaper articles or other similar evidence that the applicant has received significant attention and recognition. Evidence that the applicant or entity has been recently invited to participate in, is currently participating in, or has graduated from one or more established and reputable startup accelerators. Evidence that the applicant has played an active and central role in the success of prior startup entities. Degrees or other documentation indicating the applicant's knowledge, skills, or experience that would significantly advance the entity's business, and any other relevant, probative, and credible evidence indicating the applicant's ability to advance the entity's business in the United States. The third prong is showing significant U.S. capital investment or government funding, also known as qualifying funding through qualifying investments. The applicant can further validate through reliable supporting evidence the entity's substantial potential for rapid growth and job creation, and ultimately of the significant public benefit that a grant of parole would provide in an individual case. Meeting these criteria, however, is intended to supplement and not supplant the need to provide other supporting evidence establishing that the applicant meets the general criteria for a grant of parole under the proposed rule. Even if an entity meets the investment or funding criteria discussed here, additional evidence would generally assist USCIS officers in determining whether an applicant has met the required standard for parole and merits a favorable exercise of discretion. Among other things, such supplementary evidence may provide additional validation of the startup entity, such as receiving additional funding from a government entity, being accepted into a startup accelerator, generating significant revenue, or creating jobs. Also to show that the entity works in the fields important to economic growth, such as new technologies or engaging in cutting-edge research. Or demonstrating that the entrepreneur has knowledge, skills, or experience that will substantially advance the entity's business through successfully leading prior startup entities, having advanced degrees in the appropriate field, or establishing critical patents. Note that DHS proposes that the investment and revenue amounts specified will be automatically adjusted every 3 years by the Consumer Price Index for all urban consumers. The substantial investment must be received within 365 days immediately preceding the filing of the application for initial parole. For investments from established U.S. investors, the applicant may show that the entity has received significant investment of capital from certain qualified U.S. investors with established records of successful investments. DHS proposes that an applicant would generally be able to meet this standard by demonstrating that the startup entity has received investments of capital funding totaling $345,000 or more from established U.S. investors such as venture capital firms, angel investors, or startup accelerators, with a history of substantial investment in successful startup entities. DHS proposes to define qualified investor as either an individual or an organization. If the investor is an individual, the investor would need to be a U.S. citizen or lawful permanent resident. If the investor is an organization, the investor would need to be located in the United States and operate through a legal entity organized under the laws of the United States that is majority owned and controlled directly or indirectly by U.S. citizens or lawful permanent residents. In either case, such investor could not have been permanently or temporarily enjoined from participating in the offer or sale of a security or in the provision of investment services, barred from associations with an entity involved in the offer or sale of securities, or otherwise found to have participated in the offer or sale of securities or provisions of such services in violation of the law. In addition, DHS proposes to limit qualifying investors to those who have an established record of successful investment in startup entities. DHS proposes that such a record would include during the 5-year period prior to the date of filing of the parole application, one or more investments in other startup entities in at least 3 separate calendar years in exchange for equity or convertible debt comprising a total of no less than $1 million. DHS will require monetary commitments rather than non-monetary commitments such as credit for in-kind value, e.g. credit for services. The applicant will also need to show that subsequent to such an investment by the investor, at least 2 such entities each created at least 5 qualified jobs or achieved at least $500,000 in revenue with average annualized revenue growth of at least 20%. It will make it so that larger investors can entice potential foreign entrepreneurs by including this parole benefit when partnering up with them. Finally, DHS proposes to limit qualified investments under this rule to investments of lawfully derived capital in startup entities through the purchase of equity or convertible debt issued by such entities. It is not clear how deep the source of funds review must go, whether an E2 visa level or an EB5 level of sourcing is required. DHS proposes that a qualified investment would not include an investment from 1. The entrepreneur him or herself, 2. The parent, spouse, brother, sister, son, or daughter of such entrepreneur, or 3. Any corporation, limited liability company, partnership, or other entity in which such entrepreneur or the parent, spouse, brother, sister, son, or daughter of such entrepreneur directly or indirectly has an ownership interest. DHS is proposing these exclusions to help ensure that the qualified investment was acquired through an arm's length transaction and is a bona fide investment. Any investment that does not meet the definition of qualified investment will not count toward the criteria to meet the proposed rule's minimum investment threshold. This prevents an entrepreneur investor from gaming this proposal. Next, government grants could possibly satisfy this requirement. The applicant may show that the startup entity has received significant awards or grants from the federal, state, or local government entities with expertise in economic development, research and development, and/or job creation. DHS proposes that an applicant would generally be able to meet this standard by demonstrating that the startup entity has received monetary awards or grants totaling $100,000 or more from government entities that typically provide such funding to U.S. businesses for economic, research and development, or job creating purposes. DHS also proposes to exclude any contractual commitment for goods or services, including any contracts that might appear to be or could be made to look like an awarded grant. See alternative criteria. DHS further proposes alternative criteria under which an applicant who partially meets one or more of the above sub-criteria related to capital investments or government funding to be considered for parole under this rule if he or she provides additional reliable and compelling evidence that his or her entry would provide a significant public benefit to the United States. Such evidence would need to serve as a compelling validation of the entity's substantial potential for rapid growth and job creation. The applicant would need to show, as a preliminary matter, that his or her entity has received a substantial level of capital investment or government funding, although less than the $345,000 or $100,000 respectively. The applicant will also need to show and further validate the entity's substantial potential for rapid growth and job creation by submitting additional evidence that DHS determines to be both reliable and compelling. But it is not proposing to define the specific types of evidence that may be deemed reliable and compelling. DHS believes that to meet the parole standard in this context without meeting the threshold criteria, such additional evidence would need to be particularly persuasive. Moreover, DHS may give particular weight to evidence that tends to serve as strong validation of the entity's substantial potential for rapid growth and job creation. For example, evidence that an entity has been selected to participate in, is participating, or has graduated from a reputable and established startup accelerator or incubator may serve as, depending on the accelerator success rate and other factors, a strong indicator of the entity's potential. With respect to startup accelerators, DHS expects to evaluate them on several factors, including years in existence, graduation rates, significant exits by portfolio startups, significant investment or fundraising by portfolio startups, and valuation of portfolio startups. This gives a lot of authority to accelerators and incubators. How to renew the parole. Re-parole would be considered only when the entrepreneur and his or her startup entity continues to provide a significant public benefit, as evidenced by a substantial increase in capital, investments, revenue, or jobs. If and only if they can demonstrate that the entities have shown signs of significant growth since the initial grant of parole, and such entities continue to have substantial potential for rapid growth and job creation. Re-parole would happen with the filing of I-941 or successor forms, again with all the filing fees. Dependents would have to go through their own process as well. The application must be submitted before expiration of previous parole. The applicant does not have to leave the U.S. and re-enter to renew. DHS is proposing that an entrepreneur parolee may file a request for re-parole beginning 90 days prior to the expiration date of his or her current period of parole. In addition, DHS proposes to automatically extend the employment authorization of an entrepreneur parolee whose parole has expired but who has filed a timely application for re-parole with the same startup entity for a period not to exceed 240 days beginning on the date of expiration of parole. However, for the EAD cards for the dependent spouse, I'm not sure if they have this extension period. As proposed, an applicant under this rule would generally need to demonstrate the following to be considered for a discretionary grant of additional period of parole. 1. Continuation of startup entity. The entity continues to be a startup entity as defined by the proposed rule. For purposes of seeking re-parole, an applicant would be able to meet this standard by showing that the entity A has been lawfully operating in the United States during the period of parole, and B, continues to have substantial potential for rapid growth and job creation. 2. Applicant continues to be an entrepreneur. The applicant continues to be an entrepreneur of the startup entity who is well positioned to advance the entity's business. DHS proposes that an applicant may generally meet this standard by providing evidence that he or she, A, continues to possess a significant, at least 10%, ownership interest in the entity. This reduced ownership amount takes into account the need of some successful startup entities to raise additional venture capital by financing and selling ownership interest during the initial period of operation. And B, continues to have an active and central role in the operation and future growth of the entity, such that his or her knowledge, skills, or experience would substantially assist the entity in conducting and continuing to grow its business in the U.S. 3. Significant U.S. investment, revenue, or job creation. The applicant can further validate through reliable supporting evidence the startup entity's continued potential for rapid growth and job creation. DHS considered proposing revenue and growth thresholds that varied by industry and geographic location, but determined that such an approach would be extremely difficult to administer. DHS proposes that an applicant would be able to satisfy this criterion in one of several ways. A. Further investments from established U.S. investors. The applicant may show that during the initial period of parole, the startup entity received additional substantial investment of capital, including through qualified investments from U.S. investors with an established record of successful investments, significant awards, or grants from other government entities that regularly provide such funding to startup entities, or a combination of both. DHS proposes that an applicant would generally be expected to demonstrate that the entity received at least $500,000 in additional qualifying funding during the initial parole period. I note that potential large-scale investors can stagger their initial investment to save some of that investment funds for the re-parole period. But some questions arise, such as, is there a need to document that the funds were actually investment, showing receipts such as E2 and EB5 visa requirements? Are attorney fees included as investment as well? B. Revenue growth. The applicant may show that the startup entity has generated substantial and rapidly increasing revenues in the United States during the parole period. DHS proposes that an applicant would generally be expected to demonstrate that the entity reached at least $500,000 in annual revenue with an average annualized revenue growth of at least 20% during the initial period. And C. Job creation. The applicant may show that the startup entity had demonstrated substantial job creation in the United States during the initial parole period. DHS proposes that an applicant would generally be expected to demonstrate that the entity created at least 10 full-time jobs for U.S. workers during the initial period. Under the proposed rules, the term qualified job would mean full-time employment located in the United States with the entrepreneur startup entity and has been filled for at least 1 year by one or more qualifying employees. In addition, the term qualifying employees would mean a U.S. citizen, a lawful permanent resident, or other immigrant lawfully authorized to be employed in the United States, such as an asylee or refugee, who is not an entrepreneur of the relevant startup entity or the parent, spouse, brother, sister, son, or daughter of such an entrepreneur. Full-time employment would mean paid employment of an employee by the entrepreneur's startup entity in a position that requires a minimum of 35 working hours per week. Full-time employment, however, would not include combinations of part-time positions, even if, when combined, such positions meet the hourly requirement per week. Finally, D. Alternative criteria. As with initial parole, DHS further proposes alternative criteria under which an applicant who partially meets one or more of the above sub-criteria related to capital investment, revenue generation, or job creation may be considered for re-parole under this rule, if he or she provided additional reliable and compelling evidence that his or her parole would continue to provide a significant public benefit. As discussed above, such evidence would need to serve a compelling validation of the entity's substantial potential for rapid growth and job creation. We'll see how lenient USCIS will be in allowing this specific criteria. Material changes. DHS proposes that, consistent with filing requirements for reporting material changes in other contexts, such as the requirements to submit amended petitions when there are material changes, an entrepreneur who has been granted parole under this rule would be required to immediately report to USCIS any material changes affecting his or her grant of parole. In cases involving one or more material changes where the entrepreneur will continue to be employed or associated with his or her startup entity, the entrepreneur must submit a new application for entrepreneur parole with fee, would not include biometrics fees though, to notify USCIS of the material changes. Depending on the nature and scope of the material changes reported, USCIS may continue to authorize parole or seek to terminate parole. If the entrepreneur will no longer be employed or associated with the startup entity, or if he or she ceases to possess at least 10% ownership stake in the entity, the entrepreneur must immediately notify USCIS in writing of those changes. Upon receipt of such notification, USCIS would issue an automatic revocation of the entrepreneur's parole, as well as the parole of any dependents. For purpose of this rule, DHS proposes the term material change to mean any change in facts that could reasonably affect the outcome of DHS's determination that the entrepreneur provides or continues to provide a significant public benefit to the U.S. Such changes would include, but are not limited to, the following: any criminal charges, such as frequently seen DUIs, conviction, plea of no contest, or other judicial determination in a criminal case concerning the entrepreneur or startup entity; any complaint, settlement, judgment, or other judicial or administrative determination concerning the entrepreneur or startup entity in a legal or administrative proceeding brought by a government entity; any settlement judgment or other legal determination concerning the entrepreneur or startup entity in a legal proceeding brought by a private individual or organization involving claims of damages exceeding 10% of the current assets; a sale or other disposition of all or substantially all of the startup entity's assets; the liquidation, dissolution, or cessation of operations of the startup entity; the voluntary or involuntary filing of a bankruptcy petition by or against a startup entity; and any significant change in the entrepreneur's role in or ownership and control of the startup entity, or any other significant ownership and control change in the startup entity. Reviewing this, I see that having an active business attorney and potentially even a bankruptcy attorney on hand and discussing issues involved with the immigration attorney are going to be very important for such businesses. Failure to timely file or otherwise comply with the material change reporting requirements may result in a denial of subsequent parole applications or revocation of parole. Termination. DHS has discretion to terminate parole. It will normally give a chance for rebuttal, but doesn't have to. If it does, it usually gives 30 days for response. There is no right to appeal or being subject to judicial review. In the event of a violation of one or more terms and conditions of parole solely by the spouse or a child of the entrepreneur, parole may be terminated for the violator, i.e. the spouse or child, without affecting the entrepreneur's parole. Final note: it is good to have the entrepreneur enter the U.S. and run the company, but what happens next? A thorough discussion with a business immigration attorney is recommended. Having a long-term plan from the very beginning is necessary. The immigrant may be able to get some other non-immigrant status through O1, TN, or H1B, or potentially a green card through EB1, 2, or EB5.